Hi everyone, today we will see important legal maxim including the Tamil meaning and also important provisions in case laws based on these legal maxims. The first legal maxim is ab initio, that is from the beginning, that is from the initial stage itself. That's why in Tamil it is ஆரம்பம் முதலே. So to understand this legal maxim, there is a provision in the Indian Contract Act 1872, that is section 11 says the person competent to contract only after he attains the majority. That's why in Mohiri Bibi versus Dharmoda's case, the contract made by the minor, the court held that it is void ab initio, that is void from the beginning. So when a person is minor, he cannot make a contract. Even if he makes a contract, it will be void ab initio, that is void from the beginning. The next one is Doli incapax, which is incapable of committing a crime. In Tamil it is குற்றச்செயல் இயலாமை. So the principle behind this is it protects the children from criminal liability. So when a child does any act and if it attracts criminal liability, it won't be considered as a offense because they are incapable of committing a crime. The law presumes that the children doesn't know the consequences whatever they do. That's why there is a provision section 82 and 83 IPC which gives immunity to the children. That is, nothing is an offense done by children who's of age less than 7 years and also between 7 to 12 years. Based on this principle, we have various laws like the juvenile justice, care and protection of children. So when a juvenile commits any act, any offense, rather putting behind the bars, they will be put in observation homes for their rehabilitation. The next one is Audi, alteram, partem, that is here the other side, or no man should be unheard. That is, before deciding a case, all the parties to the suit or all the parties to the case has to be heard, which is எதிர் தரப்பினரையும் கேள். Both the complainant and the accused views has to be heard before deciding the case. The principle is opportunity for both the parties to respond against the evidence to which the judgment was made with an absolutely fair hearing. This is based on natural justice principle. That's why there is a provision in the CRPC section 313. So before starting the trial, the judge will ask the accused about his stand on the case. So it enables the accused to provide explanation or the circumstances which existed or arised against him. The next one is Actus Dei Nemini Facit Injuriam. An act of God causes legal injury to no one. In Tamil it is தெய்வச் செயல்கள் எவருக்கும் பாதகமாவதில்லை. So when any damage is caused by unpredictable natural forces, it cannot be enforced by the law. There is no explicit provision for this maxim, but in law of torts there are cases which are decided by this maxim. In this Nicholas versus Marsland case law, what happened is the defendant diverted a natural stream of river on his land to create some artificial lakes. Exceptionally, what happened due to heavy rain, these artificial lakes and waterways created damage to the adjoining land. But the court held is the defendant cannot be held liable because the cause of the flood is considered as an act of God. The next one is Nemo debet bis vexari pro una et eadem causa. That is, no person should be punished twice for the same offense. ஒரு குற்றத்திற்கு இருமுறை தண்டனை ஆகாது. That is, no person should be prosecuted and punished twice for the same offense in subsequent proceedings. It is the fundamental right guaranteed under Article 20 of the Constitution of India. It states that no person shall be prosecuted and punished for the same offense for more than once. It actually prohibits the infliction of punishment to the person for the same offense more than once. Next one is nullam primum sine lige, nulla pona sine lige. No penalty without a law. In Tamil, சட்டம் இல்லாமல் அபராதம் இல்லை. There is no explicit provision in law which defines that act as a crime, then there will be no punishment. It is guaranteed under Article 21 of the Indian Constitution. It states no person shall be convicted of any offense except for violation of law in force at the time of the commission of the act. The next one is prima facie, a first sight, a first view or based on first impression, which is மேலோட்டமாக in Tamil. So in civil and criminal law, what happens is this denotes an initial judgment whether a legal claim has sufficient evidence to proceed the trial. Here the burden is on the judge who will decide whether that particular case has prima facie to proceed with the trial. The next one is quid pro quo, that is something in return of something, which is marupayan in Tamil. So giving a thing of value or doing an act or providing a service in return of something of value is called quid pro quo. So in Indian contract law, section 2D defines consideration, that is nothing but quid pro quo. For example, when A agrees to sell his TV for 20,000 to B, now A's consideration is selling TV and B's consideration is 20,000. In Indian contract law, section 2D defines consideration, which is nothing but quid pro quo. For example, when A agrees to sell his TV for 20,000 rupees to B, now A's consideration is selling TV and B's consideration is 20,000. That is, for selling TV, B gives something in return, that is 20,000. The next one is ubi just ibi remedium. So whenever there is a right, there is a remedy. That is உரிமை உண்டெனில் அதற்கான தீர்வழி உண்டு. When a person's right is violated, the victim will have an equitable remedy under law. For example, when the defendant makes a contract with plaintiff and if he breaks the contract, the plaintiff has a legal remedy to claim the damages. That's what, when there is a breach of contract, the affected person can claim the damages or compensation for loss according to section 73 of the Indian Contract Act. The next one is Actus non facit reum, nisi mensit rea. That is, to constitute an offence, there should be an act and also the guilty mind. தீய எண்ணத்துடன் செயல்படும் செயலே குற்றச் செயலாகும். That's why the principle here is to convict the accused, we should prove beyond doubt that the criminal act was carried out with the criminal intention by him. That's why the IPC is qualified by words. Example, dishonestly, fraudulently, willfully, maliciously, unbridled. So all these words demonstrate the guilty mind, that is the criminal intention. That's why section 378 IPC, which defines theft, starts with whoever intending to take dishonestly any movable property. That's why this intending to take dishonestly is like he has a premeditated intention to steal some movable property, which is constituted as an offence. The last one is Actio personalis, moritur cum persona. That is, ஆளுடை வழக்கு ஆளுடன் முடியும். A personal right of action dies with a person. In the criminal case, when accused dies, the abetment of trial proceedings happens. Though there is no explicit provision in CRPC, the section 394 deals with the abetment of appeals. So unlike civil law, you cannot include the legal heirs of the accused to proceed with the trial, because the criminal liability dies when that particular person, that particular accused dies. That is, personal right of action dies with the person.